Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss a judgment given by the Honorable Supreme Court of India regarding the limitations to the consumer fora, consumer courts. So normally we call it as a NCDRC, SCDRC. In district level, still we call it as forum. So the Consumer Commission cannot decide highly disputed facts. The cases which are containing highly disputed facts, torts or criminal activities. Because it's a summary procedure. While dealing with the case of that is Chairman and Managing Director, City Union Bank, CMD, City Union Bank versus R.Chandra Mohan in criminal appeal number 7281 by 2009 dated 27/3/2023. Honorable Supreme Court of India, two judges bench, Justice Ajay Rastogi and Madam Bela M. Trivedi. They held that the consumer courts cannot decide the matters which are having highly disputed facts or which are having highly disputed criminal contents and tortious acts also, to be precise, because it is a summary trial procedure, section 208 CRPC. So whenever both of them appear, if someone, so you need not, summary procedure means you need not go elaborate to the procedure. You need not record the statements of the witnesses in detail. You need not get the signatures. Just basing on the averments, just basing on the discussions, you can come to a conclusion, you can pass the order. That is normally what is being done by the consumer courts, right? So let us know the facts of the case. City Union Bank is in South India, is one of the prominent banks or reputed banks also. City Union Bank. Even in Ongole also, we have got a branch near Athinki bus stand. Mr. an NRI from Malaysia, that is Mr. Chandra Mohan or Ravindran, Chandra Mohan I believe. Okay. He sent three demand drafts, 3 DDs worth about 5 lakhs, 3 lakhs and 6 lakhs to paid to D Cube Constructions for the purchase of 3 flats in Chennai. Right? So, in whose account he has transferred? He has transferred to D Cube Constructions. This is one part. So, they might have credited the amount to the particular current account of D Cube Constructions. But the pity is, the important point is Mr. Tulsiram, one of the directors and one of the partners, disputed with the other people, and actually the name of the current account has been changed from D Cube Constructions Private Limited to D Cube Constructions. తెలివిగా వీడి ఫ్రాడ్ యాక్చువల్గా వాళ్ళకి గుర్తువేలు వీడికి తగాదామని మొత్తానికి ఈ అకౌంట్ పేరు ఇలా మార్చాడు. Since he has forwarded the matter, the account అక్కడ ఉన్న NRI, Malayali NRI, D Cube Constructions పంపించాడు కాబట్టి the amount went to the account of Mr. Tulsi Ram. Then there is no response regarding the construction. Don't తీసుకున్న తర్వాత they have to give some response. No response from D Cube Construction. Then he got a doubt. He asked the Union Bank, City Union Bank people to give him furnish him the slip and other things. So everything seems to be pakka on record. But the D Cube Construction Private Limited, they say that they did not receive the money. So ultimately, this man filed a complaint before the State Consumer Forum, which has agreed the contention of the appellant, that is Chandra Mohan, and said that yes, there is a deficiency on the part of the service of City Union Bank, because they should have credited the same to D Cube Constructions owned by some other person, but it has gone to the account of Tulsi Ram. It is their fault. Then the matter went to the NCDRC. NCDRC also, same thing. They contended that there is a deficiency of service. When the matter was appealed by City Union Bank before the Supreme Court, then Supreme Court opened the entire record. And they said that bank is not vicariously liable because it is a fraud played by one of the partners. వాడు చేసింది అది, అకౌంట్లో పొరపాటు కాదు. ఆ అకౌంట్ని తెలివిగా పేరు మార్చుకుని వాళ్ళు లాగేశాడు తులసిరామ్ అనేవాడు. సో బ్యాంక్ పీపుల్ దే హ్యావ్ డన్ దేర్ డ్యూటీ పర్ఫెక్ట్లీ. ఓన్లీ థింగ్ ఈస్ ఆ డీ క్యూబ్ కన్స్ట్రక్షన్ ప్రైవేట్ లిమిటెడ్ అనే దాన్ని డీ క్యూబ్ కన్స్ట్రక్షన్స్ కింద వీళ్ళు ఊహించి చేశారు. దర్ ఇస్ నో ఫాల్ట్, నెగ్లిజిబుల్స్ అనేది లేనే లేదు, బికాస్ ఎవ్రీథింగ్ ఈస్ ఫైన్. సో బ్యాంక్ పీపుల్ దే డోంట్ హ్యావ్ ఎనీ పర్సనల్ ఇంట్రెస్ట్. Bank people had they colluded and diverted the amount, it would have been otherwise. ఇది కాదు. కాబట్టి no negligence on the part, no deficiency of service on the part of the bank of people. Only thing is, it is a highly critical issue containing the kernel element of fraud. That fraud has to be investigated by the police. This fraud has to be duly investigated by the police, not by the consumer forum. Consumer forum, after all, it's a small institution where the civil procedure code, particularly even the summary trial procedure, is followed and the judgment is given, orders are given. So in such critical cases, summary trial or the so-called consumer cases, consumer forum cannot decide the facts. Right? So the bank is not held liable as they acted in a bona fide manner. And here the NRI, Mr. Chandra Mohan, he failed to discharge the burden of proving the details of the sending of the check and other things according to section 2(1)(g) of the Consumer Protection Act. But anyway, what you have to learn from this example, from this case law is consumer courts, they can decide only matters of consumer importance, deficiency or defect in service. But they cannot go deep into the matters where some fault or criminal liability they are involved. Okay? If you know this much, it's sufficient. Please read the judgment and enrich your legal knowledge. Thank you.